somebody told me this information, and you somehow said that it's privilege, which I can't imagine, or I eavesdrop. So to me, eavesdropping is a Title 16 crime. So they brought down lawyers. The lawyers are not allowed into your courtroom.
It's not on.
No, we just.
Or they're not in your courtroom.
We just don't have any. We just don't have any space, Mr. Steele. And plus, they're welcome to go to 8H. I mean, I told Sergeant Ingram that we can let in as many as we possibly can, that we'll fill up our benches at this point in time, that won't violate our security protocols, but that 8H is available. And
8H then has to have right to counsel, because they're here, and I'm not going to.
Do you have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right. We'll let Ms. Merchant in. That's fine.
Ashley Merchant.
Yeah, Ashley Merchant.
Ashley Merchant, yes. Right, Ashley Merchant is present.
All right. Ms. Merchant, good to see you as usual. I have told your client, you represent Mr. Steele, is that correct?
Yes.
For the purposes of the contempt. I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding. By
The lawyer needs a lawyer.
Who he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however.
This is crazy.
And that's why I kind of want to know who told him that.
That's Trump's lawyer.
If he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedeas bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court, and is very, since it was a ex parte communication. We won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
And Judge, can you come up to the microphone? Sorry.
Please.
Where would you like this?
Microphone, it'll pick up, madam.
Thank you so much. Just for the record, Ashley Merchant. Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to order the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Okay. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So
this judge is corrupt.
Merchant, I'm going to disagree with you, but
well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal, you actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it
Damn.
says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Ooh-wee.
Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215
215
Georgia App
Georgia App.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those.
She's cooking, bro. Damn, she's cooking.
Anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older.
Damn.
But I do have other cases.
That is crazy. Miss Love is quiet. They don't know the law.
And Judge, I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I have space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H, and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their
They
names.
still would have to be searched and still would have to be subject to the court's protocol.
Damn.
And also, there's room in the jury box, and then there's room in the courtroom, so we would ask that they be
I
allowed to.
don't want them in my jury box, okay?
Wow.
No.
I understand.
Wow. This judge is corrupt. Wow. Bro, Mr. Steele ain't playing. YSL ain't playing. I'm sorry. The DA fucked up when they messed with
One
Jeffrey
additional
Williams and
attorney coming in,
Steele.
Alex Susor. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So
This judge
he
is
come in as
shaking.
another attorney, co-counsel.
Yeah, certainly may, sure.
Great. Alex Susor. Alex Susor. Thank you, Judge.
Damn. This is
Henry
insane.
Adams,
Hold on, this is insane.
it has two issues. One is the motion for disqualification. Okay. And that's, and I think the judge went ahead and did some other things that caused there to be that issue presented. So I don't think, Adam, I'm going to take a look at the other case.
Just mistrial, Judge. You already lost.
Georgia.
You got 30 lawyers against you.
And there's several others when you're ready.
Look at the prosecution. They're shaking, bro. Bro, they got fucking 20 lawyers outside. They just fuck with the wrong person. Dude, Jeffrey Williams got millions of dollars for these lawyers. 20 lawyers against this judge, bro. Fanny's gonna be in there in 10 minutes. This is insane, guys. This is history in law and crime. This is a history. This is the lawyer mafia, bro. Damn.
Yes. It may be one I have too.
Hasty's conduct means he got this information from. I'm not asking him by the court. That's the difference with Hasty than in this particular case. So
And
I distinguish your two cases that you've given me thus far.
oh, those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State, it's 279, Georgia 13, 2005. It also,
You said 279 Georgia what? I'm sorry?
Georgia 13.
Georgia 13?
It's a 2005 case.
right.
And it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
Damn.
See, but you all are covering under, let me see.
I'm sorry, Judge?
Hold on. Just a second. Pardon me.
Hold on. I wanna upload these real quick.
He got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however.
This is crazy.
And that's why I kind of want to know who told him that.
Because Trump's
Witness list, we're entitled to
And they can serve.
This is insane. He has 25 lawyers outside ready to defend him, but the judge won't allow more than 2 lawyers inside. That's why the whole break took so long, guys.
The contempt is directed. The trial court has the power, after confording the contemptor to opportunity to speak in his or own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He's already told me. I already gave him the opportunity to do that. So we had that conversation this morning already. So.
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
I can tell you, because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people, and as to how that information was disclosed. That's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
No, Judge, I don't agree. I believe that
I'm going to disagree with you, okay?
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum in the court is exempt from due process requirements of notice and hearing. That's even Moody. It goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told
The trial has continued. It has not.
him this. That's all. I'm not asking him to release.
He doesn't have to.
Or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but representation of your client. He has the ability to protect that information. But we don't even need to get there, because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that, because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Okay. Well.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of.
It doesn't matter. He doesn't have to snitch.
Conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned
I
it.
think that he caused that particular circumstance. I think that he had a
It doesn't matter.
conversation with somebody, and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So, at this point in time.
Oh, wow. What a corrupt judge.
You got the information.
Even need to get there because he can't be held in contempt and you can't threaten him with contempt. You even need to get there because.
Is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt.
Damn.
This needs to be heard by a different judge.
What do you got to say about that, Judge?
And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation.
The judge is silent. He ain't got nothing to say.
The court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness.
He's not saying shit.
You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
Oh my god, this is so juicy.
Whether or not he's in contempt.
Damn.
This needs to be heard by.
You got
Held in contempt, and you can't threaten him with contempt. You even need to get there. First of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights. First of all, we would ask for you to be recused from this case because you are a witness.
This judge is silent after that.
I'll let an appellate court decide that.
Oh.
Anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now.
Damn, this
For the
is
record, at this point in
crazy.
time, Mr. Steele has in fact, or has filed, and I will note this as part for the record. In this case,
Damn, this is crazy, guys. You don't understand how
he's
serious this
filed a
is.
motion to set aside the contempt. He's filed a motion for a supersedis bond, and he's filed a notice of appeal. All of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier,
Yeah.
he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, grant him a bond on that issue.
You don't get a supersedis bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
Just the case law on that is in Ray Hughes.
hold on.
Right.
Ooh, this is getting spicy.
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now.
Damn, this
For the
is
record, at this point in
crazy.
time, Mr. Steele has in fact, or has filed, and I will note.
No.
The superseded bond requirement does not apply in a contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So, you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
Wow.
The judge, and that's the reason I'm asking is because the N. Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that in fact I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Well, Judge, I think I'm addressing a slightly different point of
It
law.
is. Hold on, sir. 1 second.
This is crazy, guys.
Give you two cases. One is
Let me pause it.
it's Untema. It's a UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there's another case that I'd invite your attention to, and that is Henry Syverston. It's SYVERTSON.
This is crazy, guys.
And that is 368 Georgia Appeals.
Young Thug's like, what the fuck's going on? My lawyer's crazy.
And
You got 25 lawyers out there, bro.
decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other,
I'm not going to grant him a supersedious.
and so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
Criminal is where you get to impose a sentence, maximum 20 days and a $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he, when he tells me what the basis.
You can't just blackmail.
Who? I didn't ask what, but he tells me that, then I can certainly. He purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
Yeah, that's civil. What is he doing? You can't have the cake and eat it too.
Which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today.
Exactly. Exactly. Man, there's so many shorts, bro. I'm gonna have to make one big ass thing.
Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and a $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of
you're not doing that.
Contempt, and that is
you're not doing that because you're gonna get caught, you dumb sneaky mother.
Tells you to,
yeah, he's not doing that because he doesn't want to get caught.
going to jail.
Point of
you're not doing that.
Contempt, and that is
going to jail.
Do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who the person. Okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm going to take 5 minutes out. I'm going to think about it.
Yeah, of course.
Okay.
Of course, you need an hour break.
Right,
of
so we'll be
course.
in recess about 5 minutes.
Oh, okay. You mean an hour. What a crappy judge. Is he back live? Nope, of course not. It's been way over 5 minutes. This gives me time to upload these.
And that is
Jail.
do something, order of the court, and you don't follow. Do something.
I don't even know where I left off. I'm gonna have to look at my YouTube.
That information, Rick leads them to his
So 1.
The trial has continued. You even need to get there because first of all, we would ask for
This is crazy, guys. You don't understand how crazy this is.
No, we'll file a notice of appeal. Then we have to have a sentence.
Going to jail, or he's going to commit an offense